Good morning, everyone. We're going to get started in just about a minute. Good morning, everyone, and welcome to today's webinar. Today's topic is employer risks and liability during COVID-19 and will be presented by attorney Roy Schechter. Before we get started, I would like to take a few moments to go over some housekeeping items. My name is Hallie Schossler, and I will be the webinar organizer for today. We want to make sure today's presentation is extremely valuable for you, so we ask that you submit all questions by clicking on the question button in the control panel and typing your question. These are only visible to me, and I will collect all of these submitted questions and do a Q&A with Roy at the end of his presentation. For those of you who may not be familiar with Roy, I would like to provide some brief background. Roy is an attorney operating out of Weltman's Cleveland office. He practices complex litigation in the Litigation and Defense Group and has over 20 years of experience representing plaintiffs and defendants in business and commercial matters. He also represents employers and employees in all manners of employment-related litigation. He counsels clients on HR issues and best practices and conducts workplace investigations. Roy is licensed in Ohio and is admitted to all Ohio courts and the United States District Court for the Northern and Southern Districts of Ohio and the United States Sixth Circuit Court of Appeals. He is a member of the American Bar Association, Cleveland Metropolitan Bar Association, and the Ohio State Bar Association, with numerous litigation and employment law organizations. Without further ado, I will now hand it over to Roy.
Good morning, everybody out there in webinar land. Attorney Roy Schechter here. Really appreciate you taking time out of your busy day to join me for today's presentation, which I've titled Managing Employer Risks and Liability During COVID-19. As you heard during introduction, I'm a trial lawyer and a litigation attorney here at Weltman, Weinberg & Reese, and I handle all kinds of cases in state and federal courts involving business, creditors' rights, contract matters, appeals, and most anything else that goes to court, and doing it from beginning to end, and also represent clients before regulatory agencies and arbitrations and mediations. And during my 25 plus years practicing law, I've also always had a practice involving employment law, and I've represented countless businesses, companies, individuals in all manner of employment-related litigation, including discrimination, wrongful termination, non-compete agreements, trade secrets, unemployment, and I advise clients on all manner of human relations issues, and I do workplace investigations in situations that call for them. I've been a longtime member of the Ohio Employment Lawyers Association and members of all the bar associations that you heard and their litigation employment law committees. And as part of our ongoing Weltman, Weinberg & Reese webinar series, they said, Roy, what do you think would be helpful for our clients to know and hear about in this area at this time? I thought that nothing could be really more useful or timely than to address the global pandemic we now know as COVID-19, or the novel coronavirus as it's been called. 4 months ago, we'd have all been looking at each other going, what are you talking about? What does this have to do with law? And now it seems, I'm sure all of us every day are dealing with and addressing these issues in our personal and our business lives, and probably will continue to do so for some time to come. And so I've also been getting all kinds of questions and issues from my clients asking me, what can I do to best protect my business in the COVID-19 environment? I have employees who've been out. Many are now starting to, depending on what state you're in, are returning to work after government shutdown orders to slow the spread of COVID-19. Who could have ever envisioned to be dealing with things like that just a short time ago? Like me, you probably think the last 3 months has seemed like 3 years. And now that we have here in Ohio, and I know in other states, I know we have other friends joining us from other states near and far, but now in Ohio and in many other states, workplaces, businesses, restaurants, theaters, and in just about every other environment is opening up again. We still have coronavirus with us. We still have these issues that we need to consider, and we need to address how best to protect our businesses, our employees, and ourselves in this environment to lessen, limit, and hopefully avoid liability from COVID-19 in the work-related environment. So I put together this webinar, which I hope you'll find useful and interesting. I know I did as I put it together, and it's almost a daily thing. As I started doing this, I'm almost updating it daily. It's like ripped from today's headlines. We're seeing new environments, new things happening, new kinds of lawsuits being filed, new regulatory agency interpretations of what's going on and what we need to do. So I've tried to put together some information that's going to help our business clients navigate these uncharted waters as best we can. And I think you'll find it helpful, and forgive me if some of it is repetitive, but there's a lot of overlapping issues that we're going to discuss and best practices to, as I say, try to prepare for, lessen, and hopefully avoid the liability issues and lawsuits that are being filed just about daily here arising from the coronavirus. Now, normally, my clients come to me and say, Roy, here's the situation. How can you advise me? How would you handle this lawsuit? How can we defend it, resolve it? What are our options here? And you can usually look at the existing precedent. You can look at statutory interpretation. You can look at other things that we've historically looked at as attorneys to come up with a plan for counseling our clients and having them address the situation in the best possible way. But just like it's a novel coronavirus, it's the novel coronavirus for attorneys and businesses too. We're all learning as we go. Many of the things we're going to talk about are suggested best practices. Many of them are following governmental and other guidelines that have been provided for us. And but so many of the things that we're going to talk about, including the huge number of lawsuits that have been filed and are undoubtedly going to continue to be filed, there are no easy answers. There isn't anything we can really look at. But I think if you follow some of the best practices that we're going to discuss here today, and you're prepared and you plan, you're going to have a much better time dealing with these issues than those businesses that don't. And many of those are the ones that wind up getting sued. And there's just no shortage of theories and claims that are being made here. So as I said, so much of the material is taken from today's headlines, and there's so much. I could have written enough to do a seminar all day on this. So some of this I'm going to only be able to touch the top of it, and we're not going to be able to drill down into the depth that just about all of these issues involve. And we'll try to leave time for some questions and answers when we're done here. But if we don't have time to address all of the questions, or we don't have an opportunity to get into your particular situation in as much depth as we would like to, I encourage you to reach out to me. I look forward to speaking with you and see how I can help you navigate, as I said, these uncharted waters here. So I'm going to get to the presentation that I put together for you, and I hope you find this useful, as I certainly did in putting it together. So as you see, it's managing employer risks and liability during COVID-19. And again, please mute your phone to eliminate background noise. Hallie will be taking your questions and present them to me, and we hope we'll have time to address many of them so we can all get done by 12 o'clock. And we sure appreciate you being here today. As we said during the introduction, you see today's agenda in a very general way: how to reduce a company's employee and customer client claims and operate safely, the type of potential claims and lawsuits and class actions that are out there that are arising from the coronavirus, and we'll touch on but not really have an opportunity to go in depth on related insurance issues, OSHA issues, unemployment, FMLA, all of the things that are going to touch this, privacy issues. But at least we'll make you aware that they're out there, and then maybe we can talk again at another time or even do another presentation on some of these in more depth. I think and hope that many of you know about our firm here. While we're a full-service creditors' rights firm, we handle all manner of litigation in many other areas, including consumer commercial collections, bankruptcy, real estate matter, and all kinds of commercial litigation. So when our clients are sued, we really have the opportunity to work with them in handling whatever kind of litigation they may be involved in, both from a plaintiff's and a defendant's perspective. And we certainly do our best to comply with your security standards. And that's actually a very interesting issue as it pertains even to the coronavirus issue that we're talking about, as so many people are working at home, but we certainly keep up with and need to keep up all of our security standards. And again, you'll reach out to us as you have some more questions about these issues at another time. So we're proceeding with the presentation here, and you'll see that the heading here is that the claims and lawsuits are coming, and that's because they are. They already have started. There is no shortage of them. From just about every perspective that you see, and from every context that you see, you're going to find lawsuits and claims being made, not just by employees returning to work, but in different industries. You're going to be seeing all kinds of issues that come up involving your clients, your customers, insurance coverage and company issues. I've done a lot of insurance-related work and policy interpretation and litigation of insurance-related issues, and that is just going to be a booming area right now as courts try to figure out what is covered, what isn't covered, all the things that arise under insurance policies, and even state and federal government enforcement activities, often arising sometimes from guidelines that are provided to businesses but are less than clear, subject to interpretation, may vary from state to state, as we have some federal guideline and direction, but there's not like an overarching federal standard that we can look at. So we're kind of stuck with looking at what the CDC and other national organizations represent, along with our own states. Now, you are going to have to confront these issues, whether you work in your office environment, managing employees, you work in financial institutions, restaurants and stores, and others dealing with the public, or even in the public sector, if you're a public sector employee working for the government in courts. There's really no industry that this doesn't touch and or is going to be spared. And even as of June 15th, 2020, by some calculations, there have been almost 3,000 lawsuits filed in the United States related to COVID-19. I would submit that's probably on the low side, and it doesn't include other enforcement actions and other non-traditional lawsuit type of areas. And these include claims from customers and employees that they caught the coronavirus at work, suffered some sort of injury as a result of the negligence or other wrongdoing of their employer, or that there was something about their place of business that suggests or supports that they got sick because of something that happened at work. And that's one of the things we're generally going to try to address here today, so you can consider your own work environment, you can consider how these general themes apply to your specific situation, and then hopefully plan, prepare for, and address them in advance. Waiting till after the fact is a recipe to have a big problem with this. So hopefully you're going to come away with this today with some ways to plan for, address, and direct your activities to protecting your businesses and yourselves. It's, as I say, it's not just a business-related thing. It's a matter of protecting our employees, their families, our own families, as we're working with all the people here. We're working in these types of environments. And as I said, there's a tidal wave of lawsuits that's been filed and is probably waiting out there to be filed that range from individual claims, class actions, government enforcement. Representative suits involve just about every type of business or work environment. Some of them involve big consumer companies like McDonald's and Walmart, and some of those, and then implicate class action lawsuits that you don't want to get involved in, and to smaller businesses, even down to mom and pop stores, local businesses. Certainly, we've heard a lot of information and problems and situations to address in the manufacturing, food processing, and production environments that a lot of employers are working in. We're now seeing more as things come back. There's clubs, there's entertainment, there's travel, there's schools, the offices and the office environments brought by employees. And as I say, there are all kinds of interesting, maybe only to us nerdy egghead insurance lawyers, but really interesting insurance coverage issues that are going to have to be addressed. And just a few of the representative lawsuits, and this is all in the last few months. McDonald's in Illinois is a class action brought by employees that they failed to provide adequate hand sanitizer, gloves, and masks, the PPE that we all hear about, and failed to notify staff when employees had become infected and take steps to prevent them from being spread into other employees in the workplace. We've heard about probably Walmart had similar suits filed, and also Smithfield Meats, and some of these even involve wrongful death claims by employees there who contracted the coronavirus and passed away, unfortunately, many of them alleging the same kind of failure to protect employees, abide by CDC and state guidelines. So as we go through this today, if you take anything away, just realize that really the best way to try to protect yourself is to be aware of and follow, and make sure your employees are aware of and follow whatever CDC guidelines and state guidelines there are. In Ohio, we were having for months daily briefings from the governor and health director, and providing all kinds of information on COVID-19, on infections, on spreads, and as things have opened up on issues involving opening up. I understand some states have had similar types of information being provided regularly. I understand that others have not. And so it's kind of incumbent on you as the employer to try to stay up on this, try to stay ahead of the curve. And that's really one of the best ways you can protect yourselves and your businesses and your employees in this environment. I mean, even as I'm doing this and putting this presentation together, literally as I'm driving to work today, I hear the report of yesterday. It was reported as of yesterday, June 17, 2020, workers at a large Dole vegetable plant in Clark County, Ohio. Well, you didn't know they had a Dole vegetable plant in Clark County, Ohio, which is kind of a rural county between Columbus and Dayton. Well, we do, and they actually process a lot of the Dole bagged vegetable and lettuce and things like that you see at your local supermarket. Well, they had approximately 200 workers that tested positive there. Yes, as reported yesterday, they had a prior positive test in April. And I'm reading the news story that I printed out when I got to work and added to this presentation. And the company representative, of course, says that, there's nothing more important to us than the safety of our workers. And our plant will continue operating with additional safety measures, such as employee temperature checks before entering the plant. And I say to myself as an attorney, oh, you had a prior experience in April where somebody had tested positive, and now in June, you're just going to have a temperature screening for your workers after 200 more employees tested positive. That's an invitation to get sued by a whole lot of people. And it's also unfortunate if you think of the 200 people out there in rural Ohio who've been coming and going and interacting with their family, with members of the public, maybe you and I, who've had or may have had coronavirus. As we know and are learning almost on a daily basis, people who may be asymptomatic may actually have a coronavirus and could be spreading it. One of the things that really makes this tricky and different than other types of flu and viruses that we've had to deal with. So that's as of yesterday. There's also suits by employees trying to have temporary restraining orders put in place, or orders from courts to compel employers to do certain things, in this case to meet or exceed CDC and state COVID guidelines. And parenthetically, I say that one of the ways a lot of these suits and claims are coming up are by employees that are returning to work or maybe have not left work, who are seeing that their employers are not doing all that they could to protect them. And those employees are dropping a dime on their employer. They're calling for various regulatory agencies and OSHA, and they can do so anonymously and saying, hey, please get in here to maybe the Dole vegetable plant in Clark County, Ohio, and check them out because they're not doing what they need to do. And you also, in addition to not wanting getting sued in private litigation, you don't want the government breathing down your neck. You don't want the government suing you or taking its own regulatory action, which can result in fines and various orders that you'll have to comply with anyway. And those often work hand in hand with lawsuits and become evidence in lawsuits. So you don't want to go there. So that's why, in addition to being the right thing to do, you got to try to look out for your employee safety, because if you don't, they're going to find somebody who will. This also affects, debt relief, as some of the things that Weltman Weinberg has departments that are involved in lawsuits seeking suspension of student loan repayment programs based on changed conditions. There have been lawsuits seeking to suspend foreclosure actions. There have been various lawsuits and even governmental orders, including here in Ohio, that precluded going forward with eviction actions. Those actually were just now lifted, at least in the city of Cleveland, and they're allowing evictions to go forward again, and going to handle many of those by remote hearings, which will be challenging in itself. And even going back to court at this time is very challenging. Some courts are not open. Some courts are open with very limited restrictions, and others are trying to handle hearings and even trials remotely, which is very challenging. Other lawsuits that we've heard about, and many of these I understand the basis of them, suits against colleges for breaching contracts, seeking refunds of tuition and room and board. My child didn't go to college during this period. My child wasn't able to attend in person. And we can all look at our own experience. Is the learning environment from home the same thing the child was getting from the college that they were paying a lot of money to go to? Hey, I paid for room and board, and my child wasn't there and had no room and board for X period of time. Those are significant types of claims, and you can see universities from all over the place that are being hit with these lawsuits. Many of them might not just be on the basis of one individual, but they may be part of group or class action lawsuits, or the resolution of them are going to lead to necessary The same result being for other similarly situated students. As I say, it's all over the country, from California to Boston here, and everywhere in between. There's employment-related lawsuits that may be more directly related to some of the things we're talking about here today. Failures of businesses, particularly large companies, to follow WARN Act, which is Workers Adjustment and Retraining Notification Act of 1988, which requires certain notice be given before mass layoffs, that certain layoffs be done in particular ways. And we certainly heard of lots of companies that were simply laying people off, as of tomorrow. And some of those are alleged to have violated the WARN Act for the manner in which they laid people off. There are also lawyers that are considering who was laid off during this coronavirus, and are they using the pandemic as an excuse to lay off or terminate certain employees in protected classes that would otherwise give rise to discrimination claims, that this is a pretext to lay off older workers, to workers who they think might bring discrimination claims of various things based on protected classes. So that's out there as well. They said even state employees are bringing actions, and a lot of employee unions are bringing actions against state and local governmental entities seeking injunctive relief to provide for manners to reduce their health risks. And there's other things related to entertainment industry. Probably not a great time to be in the cruise ship business. Airlines, we've all heard of airlines, some of which were required to refund canceled flight payments. Instead, they're offering vouchers to be used during a certain period of time when it may be alleged that they weren't permitted to do so. And there have been a number of them filed against large air carriers already. You see some of the dates here, just within the last month or so. Some of the other employment-related suits, to pay money so your kid could go on that Washington trip with the high school. Did they get their money back, or is it being held? Same thing with other educational tours. And we've found cases, quite a few of them, involving event and ticketing companies who seeking refunds of payments that have been made for sports, music, theater, cultural event tickets, and other things based on breach of contract or consumer protection laws that we have in Ohio and most states do, where money has not been refunded for that's already been paid. If you were a season ticket holder of a baseball team like the Houston Astros, you paid money to SeatGeek for concerts that didn't happen. You bought tickets from Live Nation or Ticketmaster for your favorite upcoming summer concert that may have been postponed, may have been canceled. Only on some pressure did they start refunding money from events that were called postponed but weren't canceled yet. Now many of them have, and I can tell you from personal experience, Ticketmaster has a way, if you go on their website, within the next period of time from an event now being postponed or canceled, you can request a refund of your money or allow them to hold it until the event happens. And Ticketmaster was offering you 150% of your money back towards tickets next year if you didn't ask for your money back now. All of these are lawsuits that have happened just in recent weeks and months. I said there's all kinds of employment-related lawsuits continued here. You paid your money for fitness clubs, annual ski resort tickets, amusement parks, and season passes. Did you get your money back? You have an option for doing so. And how are they handling those claims if you need anything? If you need something refunded, your fitness club, is it back open? Is it doing what it needs to do? You may have paid money to belong to a private club, whether it's your country club, your tennis club, your swim club, things like that. And it may be, again, that you are not able to use it for a period of time that you've paid for. And of course, we've heard about healthcare providers and nursing facilities, and so many of them in many places, particularly in nursing care facilities, residential care, and other group facilities. Those are probably some of the most fraught with danger areas here. And as we know, very unfortunately, the coronavirus seems to be most severe with the most susceptible among us. Many of the elderly, many of the folks that are in these residential care and nursing facilities are the ones who, when they get sick, have the worst outcomes. And there have been a number of class action litigations against large healthcare and nursing providers alleging that they failed to properly respond to the pandemic here. And there may be states, and there are certain states that have passed laws very recently limiting civil liability for these and other related claims. Just in the last few months, the states that I've found that had executive orders to some degree to shield healthcare providers from civil liability include Connecticut, Illinois, Massachusetts, Michigan, New Jersey, and New York. And I think Pennsylvania recently passed something similar. So now as we kind of get closer into our own work environments, you want to make sure that you're following whatever OSHA, Occupational Health and Safety Administration guidelines there may be, because they are stepping up enforcement, having the authority to issue fines, close businesses, file lawsuits, and mandate compliance. As I said previously, employees and even customers, really anybody, can contact OSHA with anonymous complaints about the concerns and problems they have with work environments or stores or other places of business, offices that they feel are not following appropriate guidance, and those are the ones that are going to get looked at first. So that's much of the reason why you want to make sure your employees and your customers and your clients are informed as well as you can about what you are doing to protect them, what you're doing to protect the work environment, and how you're meeting the various OSHA guidelines. And in many cases that they're looking for certain things. Do you have a written pandemic plan, which is recommended by the CDC and something that I would recommend and have helped some clients put together? Do you have procedures for hazard and risk assessment? Do you have PPE protocols that are suitable to your work environment? Are you giving employees the training that they need, the prevention of COVID-19, and making sure that they're aware of it and abiding by that? I also note that OSHA requires businesses to keep records of positive COVID-19 tests where they believe that the case could be work-related, and you want to be sure to do that. And again, subject to what we'll touch on briefly, certain privacy issues that we still have to maintain with regard to individuals, but we certainly can let people know that there has been a positive test and what we're doing to try to prevent that. As a trial lawyer, I said to myself when I see all of these lawsuits being filed, one of the most interesting issues is proving the proximate cause of the particular injury that's involved or of the breach of contract that's involved. Is this work-related? How are you going to show if something, the proximate cause was something that happened in the work environment? Very difficult to do. And that's going to be one of the defenses that's really going to be looked at and relied on in these kinds of lawsuits, because people don't live at work, they go home, they interact with others, they go to stores, we don't know what they're doing on their own time. But OSHA has developed certain guidelines as to determining whether a particular injury or illness is work-related, and you see them here. It's likely work-related if, and they give some examples of that, where several cases developed among workers who work closely together and there's no alternative explanation. That's probably the most likely one that is going to help establish the proximate cause. The 200 employees in a one dole plant in rural Ohio that are getting sick. Was it contracted, shortly after a lengthy exposure to a particular coworker, a customer who had a confirmed case of COVID-19, and there's no other alternative explanation? Their job duties required frequent close exposure to the general public in localities with ongoing community transmission, and there's no other explanation. But as we're seeing now, that any community can have ongoing transmission, whether it's in big cities that we've all seen. We've certainly seen it here in the Cleveland area. We've seen it in most big cities, but we're now seeing it in much more rural and much more isolated areas as well. So nobody's really immune from this based on geography. If this person is the only worker to contract COVID-19, if her job duties didn't include frequent contact with the general public, then it's likely that this wasn't something that was caught at work. And again, and it's likely not work-related if the employees, you see, outside the workplace frequently associates with someone like a family member or significant other who has COVID-19 and is not a coworker, and it's during the time of exposure when that person was likely infectious. But the proximate cause issue is something that's really going to be litigated during the resolution of all of these lawsuits, and it's going to be interesting to see how that works out. A lot of employers say, hey, I got insurance coverage for that, You think you're covered? You might want to think again. I'm calling this the Full Employment Act for insurance lawyers, because there's so many policy issues and exclusions and definitions that are implicated by what's going on here. And we're going to see how these play out. And these are not just in the context of businesses seeking coverage under their various personal injury coverage that they might maintain and liability coverage that they might maintain. There are lots of suits being filed by insurance companies seeking declaratory judgments that their policies do not cover certain COVID-related issues and negligence theories and other kinds of theories. Most of your policies, if you ever actually read the 60 pages of your business policy, it'll give you a headache as you look at every one of these definitions, exclusions, and coverages. And you'll see one of them is that most likely there is called the force majeure, which is the occurrence of an event which is outside the reasonable control of a party and which prevents that party from performing its obligations under a contract. It's generally things that neither of the contracting parties could have contemplated at the time of contract. That means that there really wasn't a meeting of the minds as to coverage for a particular type of claim that's being made. In this case, it's exposure to a novel coronavirus. Many have an act of God and national health emergency provisions. So you may want to look at your policies. You may want to consult with your insurance representative and take a look at that and see what's covered and what isn't. I just put a representative, just a small representative example of insurance-related suits that we see here and that have been filed, and there's just too many of them to count. And a lot of these are going to be very important in determining what coverage businesses have for both employee claims and for third-party claims against them. As I said, the best way really to try to get ahead of this and protect your employees is to go through, be familiar with, and try to comply, with your CDC guidelines. And the Center for Disease Control has put out a lot of directives being updated frequently, sometimes weekly, that include many of the highlights or things that we all know of. These are the basic things that we all know we all should be doing, which are actively encouraging sick employees to stay home, considering conducting daily in-person or virtual health checks of our employees, identifying where and how workers could be exposed in the workplace, separating sick employees, and educating employees about the steps they can take to protect themselves at home. For business operations, some of the things that you can do to help you comply with these guidelines, many of you probably are, implementing flexible sick leaves, making sure that the employees at higher risk categories are getting all of the protection that they need, establishing policies for social distancing in the work environment, considering improving the engineering in your building, make sure the ventilation system is working at maximum capacity, giving employees, customers, and visitors every opportunity to clean their hands, to have access to hand sanitizer, and they're covering coughs and sneezes, perform routine and regular cleaning. You may need to, and probably have been required to, limit travel of your employees and advising them what they need to do if they travel to other states. And you want to minimize the risk to employees when planning meetings and gatherings. And you might find, and many have, my firm has had great success having workers work remotely, having group conferences, using various technologies to get the work done while minimizing the risk to people by being with each other. And we've really found it to be effective. And our tech department, our IT department's done a great job in setting up pretty much everybody, hundreds of employees, with ways to work at home, providing laptops and computers if necessary, installing all of the security protocols that we need to operate under. And it's worked pretty well, and I think has really helped our place of employment to, knock on wood here, not have any problems thus far. As I said here, I just did a quick listing of CDC guidelines, and some of the things that you want to do are conduct a workplace hazard assessment. What do we need in our particular environment to provide to our employees to keep them safe, and do your best to have plenty of the PPE necessary on hand. I understand it has been getting easier now as time's gone on to get the things that we need, the masks and gloves if we need those kinds of things, and where possible to use them. It's important, though, none of this is going to matter if you don't provide employees with training on things, how they can reduce the spread, the general hygiene symptoms, what to do if they're sick, how to clean and disinfect their workplace, using cloth face masks where possible, social distancing and safe practices and stress management. So you're going to want to look and see what can you do in your work environment and within the facilities and equipment you have to maximize safety for your workers. And some of the things that have been done, I know that we have done here, to maintain social distancing, see if you can reconfigure the workplace to keep people farther apart. Using partitions and barriers or shield, use plastic dividers and barriers. The things that we see in stores, moving the electronic payment away from the cashiers, verbal announcements, signage, and distancing. I'm seeing a lot of businesses actually appointing someone to do that, and it's a good idea to consider appointing someone as a point person for this kind of things. I was checking out at Trader Joe's recently, and while they're doing everything they can to limit people in the store and keep people safely apart and putting the wait here things on the floor, as you're checking out, they have an employee whose only job is to go up and down the checkout line and make sure people are abiding by all of that, and they're very short to let you know if by accident you're getting too close to somebody, and those are the kind of things that are really going to help them if there's any kind of employee or third-party lawsuit that they have to confront. So these are some of the things. I said some of this is going to be redundant, and I want to try to get through much of this material, but how do you protect your business? Here's the 8-step plan to protect your business. You want to consider your workplace safety, your recall procedures. How are you going to recall your employees and when? You want to consider from HR perspectives whether there are employee benefit issues that you need to consider. Similarly, compensation issues that may need to be adjusted or take into account time that people were out, may have been furloughed, cut back to work, considering the remote work opportunities for those that can do so, making sure to communicate what you're doing with your employees and with third parties, and considering policy changes going forward, as unfortunately this may be continuing for a while, and have business continuity plans if unfortunately you have a number of people who get sick in your work environment. So again, just going through some of those issues quickly, and we'll make these available for you to those who'd like. Implementing employee health screening procedures. We make all of our employees take their temperature before they come to work, and attest to a person who's recording this that they are, don't have a fever at this time or other symptoms. Making sure to provide the PPE that's necessary, including the mask, gloves, sanitizer, and thermometers. Quick note on thermometers. It concerns me when I see people using these handheld thermometers, because I have a fancy handheld thermometer that I got just when this was starting, and I also have a 15-second under the tongue thermometer, and I will tell you that the fancy, expensive, no-touch forehead thermometer does not work well. And I've heard this from many people. It'll give me 5 different readings on 5 different times, and then I use the other 15-second under the tongue, and it gives me a much more reliable reading. There's something to consider. So also want to consider your cleaning procedures that you're using. You want to also note your cleaning procedures. It may be that somebody's going to be appointed to do this, and you're going to keep track of when you do it and how you do it. Stagger your shifts at lunch breaks. We don't want to have people standing around the common, water cooler, using the same coffee pot, putting everything in the same microwave. These kinds of things are the kind of group activity that can lead to spread of coronavirus. You may want to regulate, or in some places even eliminate, a common lunchroom. Maybe employees are eating lunch in their car, they're going elsewhere, they're bringing their lunch, but you got to try to maintain the social distance in whatever's going on in your business. We've been having some success rotating days of the week that certain employees are in the office or working remotely, keeping down the numbers, increasing distance, and the moving workstations to maximize distance, implementing the traffic patterns, the lines on the floor that we keep seeing, and installing plastic barriers when available. Probably being in the plastic barrier business, plexiglass business, would be a pretty good area right about now. Business travel, it's probably not something you're going to be able to do for a while, and even if you travel to certain states, you may have quarantine restrictions when you get there, so you're going to have to look into that before there is any business traveling being done. And you're going to want to look at customer and visitor contact protocols for those of you that are dealing with the general public. You got to make sure that the general public knows what you're doing and abides by whatever regulations you have. I've had a lot of clients ask me, Roy, I'm a private business, can I mandate that people coming into my work environment wear masks? And the answer is yes, you can. You're a private business. If that's what your rules and regulations are, you can say, please, we require that you wear a mask while you're in our place of business, or we prefer that you not come in right now, or let's set up some kind of remote way of doing business, but you do have the option for doing that. And again, as you do these things, the record keeping of what you're doing is going to be some of the most important evidence that you'll need should you ever be confronted with proving what you did. You have recall procedures that you're going to be considered, who you're going to recall, at what time. And as I say, you can do it in most any way you want, but you have to consider, are there any seniority issues we have to abide by? Are there union issues that are implicated? And you want to make sure to do so in a manner that can't be alleged that it's discriminatory in some manner. You're going to have issues where you're going to have employees who've been out, maybe they were furloughed or maybe they were on unemployment, you're calling them back to work. How are we going to call them back to work? What are we going to do with employees who feel they're unwilling to return to work? You want to handle that carefully. You want to figure out why are they fearful from returning to work. Is there some kind of high risk that they have that makes that legitimate? Is it just a general fear of coronavirus? If it's legitimate, they may be entitled to continued unemployment depending on what your state is and what the state unemployment guidelines are. If it's not objectively reasonable, they may lose their unemployment. And when you call an employee who doesn't have a legitimate basis not to come back to work, and they may be in a position where they're not going to be able to continue receiving unemployment, and you're entitled to let unemployment know the situation with that particular employment so you don't keep paying for any amount related to them being out. I'm not going to go over these in great detail, but just there's all kinds of HR issues that the HR professionals are going to need to look to their particular work environment to figure out. Group health insurance, flexible spendings accounts, 401ks, paid leave, all of these may be implicated by employees who've been out for a number of months coming back to work. There are compensation issues that may need to be addressed, including pay increases. Maybe they were hazard increases. How are they going to be applied going forward? Were there salaries that were reduced during COVID-19 and are going to be restored? Are bonuses affected? Is there hazard, and as I said, hazard pay that may have been offered, is it going to continue? And it might be a good time to edit some of your employment compensation related issues, some of which may have been frozen or may have impacted certain groups differently during COVID-19. We've talked about remote work. It may be that remote work has been going well for you. I've heard from a lot of clients that somewhat to their surprise that working remotely has allowed to maintain productivity, sometimes even increased productivity. People don't spend the hour or two commuting to work and are able to work and get work done at other times. You might want to consider updating your technology and making sure that it supports virtual workers, as you may want to continue that. And you might even factor in whether there's cost savings for you by having people work remotely that ultimately will allow you to reduce your footprint, to pay less rent, to not require as much physical location to get your work done. You want to make sure that you're communicating all of these things to your workers and customers, and you want to detail whatever you're doing. You may want to make posters and notices that you're placing around the workplace, that you're putting on the door for third parties coming in, that you're making sure everybody understands what you are particularly doing to protect them and your employees. If you have a problem, you may want to consider how you're going to deal with media communications. Who's going to handle that? Who's going to speak for the company in this? And so you'll be prepared to respond to media and workplace exposure. As I say, there's a number of policy changes that you can and should evaluate and consider whether change is appropriate or necessary in this environment. I want to go ahead to get to a couple of issues that have been important here, and so I'm just flashing through things like your business continuity plans. What are we going to do if a number of people get sick? And there are things that you can do ahead of time to try to ensure that there won't be any significant disruption to your business. These are a couple of checklists that I put together that you'll want to look at in considering employees coming back to work, which you can go through, and many of them include some of the information I've talked about already, and are both complying with CDC and state guidelines and common sense at this point. And you want to make sure that you've got whatever reporting plans you have in place so people know what you're doing, so employees know what you're doing, customers, clients know what you're doing, and you can then document your compliance with your own plans here. As I said, many employers are designating a point person or persons at various work sites and departments to address employee concerns and ensure compliance and actually recording what is being done and how they're doing it to protect their employees. And again, these are things that many of which we've talked about, but your plan's not going to do any good unless you effectively communicate that to your employees and other people that need to know it. Okay. Again, this is just how to document some of the things that you're doing to provide for safety. And again, doing it is one thing, being able to document and prove it when the lawsuit is filed or when OSHA comes in to talk to you, that's going to be critical as well. And that's some of what these last couple slides are letting you know about. And so we have talked about a number of these things, as I say, just scratching the surface of them previously. But I want to get to, in the little time that we have left here, these are just OSHA workplace compliance that you can probably Google and find as well very easily. It's very readily available. The CDC has its own website, as does OSHA, that you can take a look at, and it's very easy to find the COVID-related information on there. I'm again going to skip over some of the other HR stuff, wage and hour considerations, but there are a number of them that you're going to have to address. Many are employer-specific, depending on what you're doing, and other HR considerations, just a little checklist of things you might want to go down for the HR professionals that may be with us here, so they can ensure that they're not missing anything that they might otherwise want to consider in their workplace. So those are here for us as well. There are privacy considerations, so you got to still keep that in mind. As I said, if somebody tests positive, you don't want to say that Mr. or Mrs. X tested positive, and everybody be aware of that. However, those that need to know, those that were working nearby them, you can let them know that they were exposed to someone who may have COVID-19, and that they should be on heightened awareness, and that you will be requiring them and monitoring them to make sure that they are not going to get ill or infect other people as well. The last thing I want to get to is, probably I've had more questions about this than anything else in the last month or more, are like the kind of personal injury considerations that you'll have to look at as to confront the kind of lawsuits you might have. I talked about it, discussing insurance coverage with your broker or other people that can advise you. Whatever you do, as far as what we're going to talk about now, which are waivers of liability or notices of risk here, and related to assumption of the risk, none of that is going to eliminate any obligations you have under workers' compensation law. You can't have a waiver of workers' compensation law in Ohio. And you're going to be mindful that even if you have employees or third parties sign waivers, those waivers do not cover intentional or grossly negligent or reckless activity. And so while they may be useful, they're not an absolute way to insulate yourself from liability. So again, these personal injury considerations are many of the things that we talked about already, as to following guidelines and doing your best to monitor compliance. So I have an employee questionnaire here that you can hand out to employees coming back, that just documents whether there's COVID-related issues that they have dealt with, so you can try to see, are there people that maybe have been exposed to COVID and that you should be on heightened awareness for them. You can put up front door signs so people coming in and out of your office know what you're doing and know what you don't want them to do. You don't want them to come into your business where they have any of these COVID-related symptoms, and you can say, if you have any of these, please do not enter this business or this building. And that's the same thing, posting notices in the workplace so employees are reminded of all of this, being sure that they're washing and sanitizing their hands as often as possible. I know employers that are giving hand sanitizer to put on everybody's desk, saying use it all the time. Wipe down the copy machine, the phones, the common touch points, and that can be helpful. These are some management talking points I put together to talk to your employees as they come back and explain to them what you're doing. And I say we're running low on time here, and the one things I want to make sure to get to here are these waivers and limitations of liability. Depending on the nature of your business, you may want to utilize some waivers, and I've prepared some and can help you prepare some for your particular environments. And limitation of liability forms, where waivers are where a third party or an employee expressly agrees not to sue you if they contract COVID-19. As I said, employees are subject to workers' compensation related issues, and the effectiveness of these forms to limit liability haven't been determined yet by the courts. They're generally enforceable waivers of liability in the commercial context. They're often effective in an individual in employment context, subject to some of the exceptions I mentioned, and you should consider the value of them versus whatever effect they might have on company goodwill. As I say, customer waivers of liability can prevent certain liability, like common negligence suits, but not everything. It's not going, and they don't apply to anything alleged to be willful, intentional, or grossly negligent. So if you don't follow the guidelines we're talking about, you don't do any of the things we're talking about, and you have a waiver, it's less likely to be effective. And again, this is a sample of a customer waiver prepared for a business that does business with third parties coming into a work environment, and you're telling them what you're doing, and you see that they're agreeing that they are agreeing to release you from any and all liability from being exposed to coronavirus at their place of business. Again, how this will be enforced is subject to being decided by courts, as a lot of these lawsuits we talked about are going forward. And as I say at the bottom here, it's nice to have waivers in place, but you better be prepared to prove you followed your own rules that are set forth in the waiver, or it's not going to be or less likely to be effective. I told you about employee waivers. You can have them. They're probably less likely to be effective. There's questions about whether there's equal bargaining power between an employer and somebody coming back to work who needs a job and wants to work there. And as I mentioned before, there's 5 states that have already enacted statutes limiting liability for coronavirus 19 claims. Now, again, there's a concept of difference between a waiver and an acknowledgement of risk. Acknowledgement of risk is telling people that, hey, you're going to be exposed to risks as you are in all environments, and here's a risks incumbent in our work environment. And their signing that isn't a waiver of the right to sue you, but it supports a assumption of the risk of defense if there is a lawsuit filed. That's an important distinction. But if you've informed somebody of the risk and they nevertheless make a knowing and voluntarily determination to proceed in light of being aware of that risk, that's going to support your assumption of risk defense. And I'll end by talking about what just came out the other day, which is the Buckeye Pledge, which if you're an Ohio State Buckeye football fan, and maybe a fan of your own local university football team here, and the Buckeyes had all of their pledges as they're coming back for practice, which is actually starting right about now. They're telling them everything they're doing to protect them as part of the Buckeye Nation. They're requiring that, particularly in this case, athletes, and I expect to see this for students going back to colleges and schools as well in the fall, telling them that, hey, you know that it's dangerous. You're living on campus. You might be eating in dining halls, attending activities, participating in sports events. You may be exposed to COVID-19. To reduce my risk, you're going to do all of these things that many of which we've talked about to monitor yourself, and you're going to make sure that if you believe you have COVID-19, you're going to quarantine yourself and follow the appropriate guidelines in whatever state you have. You're telling them what the symptoms are so they know what those are, and showing them, where they can go for additional information. If you get sick, if you feel sick, you're going to stay home. And if you you're going to fully and honestly let, in this case, the athletic training staff know of any possible problems so they can do contact tracing where appropriate. They're requiring that all of the athletes wear a mask and appropriate PPE in public places, social distancing, washing, sanitizing, all of those kinds of things. And at the end, they're not saying, I hereby waive my right to bring a lawsuit, but they're saying, I've read, understand, and agree to comply with my Buckeye pledge above, and understand that that's a condition of my participation in Ohio State athletics, and the failure to do so may result in the loss of certain participation activities. So I expect to see these in many contexts as people return to work, but that's not a waiver. It's a notice of the risk that you're going to be confronting, so you can establish that they have assumed the risk that may be covered in whatever they're doing. That's pretty much the end of what I have here. As I said, I'm sorry for running through this, but there's so much information, and every one of these slides you could have talked about for a long period, but I wanted to give you the 100-foot view here of the things to be aware of, the things you might want to think about in your business, and how to plan for and best protect yourselves. You see why this isn't a live webinar. I've got a great face for radio here, as I say, but here's my contact information, and I'd encourage you to reach out and talk to me if there's anything that I can do to assist you. You got my phone number, 216-685-1062, and my email address is up here as well for you. And I certainly encourage you to reach out to me if there's anything I can help you with or you'd like to talk about, and it would be my pleasure to do so. So that's the end of my presentation here today. I'm sorry, I don't know if we're going to have any time for questions right now, but I'll let the moderators take it from there.
Thank you, Roy, and thanks everyone for joining us today. I hope you found this presentation beneficial. I know Roy just said it, but I again want to invite you to reach out to him for any questions you may have, and apologies that we ran out of time for those today. Other than that, keep an eye on our website, weltman.com. We do have more webinars coming up in the future, and they are always being updated. Thanks everyone for joining us. Have a great day.